severed from the surface estate, that's called a severance, and they become severed minerals. And I've quoted some language here from South Dakota's case, Broadhurst versus American Colloid. Minerals in and under land are a part thereof until they are severed from the land. Severance of a mineral interest from the surface estate creates two estates, which are separate and distinct. Severance may be effected by deed or by reservation. So the example of that would be if it's a severance by deed, if owner owns the surface and the minerals and conveys the minerals to B by a mineral deed, that act would be a severance. The surface estate would be separate from the mineral estate which was conveyed to B. A severance by reservation could occur if A owns both the surface and the minerals and conveys the surface to B but reserves the minerals. Then there would be a severance. B would be the surface owner, and A reserved the minerals, thereby severing the two estates. In example 2, rancher owns the surface and 100% of the minerals in Whiteacre. Big Oil buys 1/2 of the minerals. Rancher conveys an undivided half interest in the minerals to Big Oil Company by mineral deed. The question is, could rancher convey 1/2 of the minerals to Big Oil Company by warranty deed? And the answer is yes, he could. But we would recommend that you use a mineral deed, so when you're examining title, there's no question that only the minerals were conveyed to Big Oil. The surface was not at all included. Question 2. If rancher later conveys the land to farmer by warranty deed without any mention of the minerals, who owns the minerals? The answer to that question is Big Oil owns 1/2 because 1/2 of the minerals were conveyed to Big Oil by rancher. And then when rancher conveyed the surface to farmer and made no mention of the minerals, farmer received the surface estate and the remaining half interest of the minerals that were reserved by rancher. And that's a poor way of stating it. The remaining half of the minerals that rancher did not convey to Big Oil automatically is conveyed to farmer. I want to talk a little about reservations of minerals. Reservations of minerals are customarily included in instruments that convey the surface or partial undivided interests of the mineral estate. For example, example 3 shows rancher owns the surface and 100% of the minerals in Whiteacre. Rancher conveys Whiteacre to farmer but reserves 1/2 the minerals in the warranty deed that I'm showing you. If you look, the warranty deed says that rancher grants, warrants, and conveys Whiteacre to farmer. And then there's language in that mineral reservation that shows, right after your legal description, in your deed, you can include language like this that says, accepting, however, from this conveyance and reserving to the grantor's heirs, successors, and assigns an undivided 1/2 interest now held by the grantor in all minerals of whatever nature. So the question is, who owns the minerals after that deed is recorded? If you recall, rancher is conveying the surface to farmer and reserves 1/2 the minerals. So rancher still has half the minerals go to farmer. Question 2 is, can farmer lease the minerals to Big Oil Company? The answer is yes, but farmer can only lease the 1/2 interest in the minerals that he owns. Rancher still owns 1/2. He would not be bound by any lease that farmer enters into. To continue that same example, if farmer later conveys the minerals to Big Oil Company with the following mineral deed, that mineral deed, if you look, says farmer conveys an undivided 1/2 interest of all my right, title, and interest in and to the minerals in Whiteacre to Big Oil Company. That deed's recorded. The question is, who owns the minerals? And the answer is, rancher reserved 1/2, so he has 1/2 the minerals. Farmer received 1/2 the minerals when he purchased it, and now he has conveyed 1/2 of my right, title, and interest in the minerals to Big Oil. So Big Oil owns 1/4, and Farmer owns 1/4, because Farmer only conveyed half of what he owned, and a half of a half is 1/4. Question 2 is, who owns the surface? Farmer still owns the surface. He received that from Rancher, and then he later sold a portion of the minerals to Big Oil Company. He has not yet conveyed any interest in the surface estate. Example number 5, Orville owner owns the surface and 100% of the minerals in Whiteacre, and owner conveys Whiteacre to Rancher by warranty deed, but reserves half the minerals. Rancher then conveys Whiteacre to Farmer by the following deed. Warranty deed says, Rancher grants, warrants, and conveys Whiteacre to Farmer, subject to all reservations, easements, and rights of way expressly conveyed or reserved in prior grants or deeds are created by operation of federal or state law, which is a pretty common clause you'll see in deeds. The question is, who owns the minerals? After that deed's recorded, the owner owns 1/2 of the minerals. If you recall, he reserved 1/2 when he sold the property to Rancher. Rancher owns no minerals. He conveyed his minerals when he conveyed the surface to Farmer and made no specific reservation of the minerals. And Farmer received a half interest in the minerals when that deed was recorded. The second question is, what if the warranty deed did not include the subject to language? The answer is there is a potential claim for breach of warranty. The warranty deed simply described, contained the legal description with no subject to prior reservation language included, so it's presumed that the entire fee estate of the property is being conveyed to Farmer. So Farmer has a potential breach of warranty because he would not be receiving 100% of the minerals. Now I'm going to attempt to talk about the Duhigg rule, which is a commonly violated rule, and it's something that people need to be aware of when dealing with minerals. And it comes into play when there are partial undivided interests. The Duhigg rule comes from the case that I've cited, Duhigg versus P.V. Moore Lumber Company. The question is, what if the grantor owns less than the full mineral estate and reserves a portion of the minerals? Here's an example. Orville owner owns the surface estate and 100% of the minerals. Owner conveys Whiteacre to Rancher by warranty deed and reserves an undivided 1/2 interest in all oil, gas, and other minerals. So we've got Orville owner's got a half of the minerals. Rancher then conveys Whiteacre to Farmer by warranty deed, reserving an undivided 1/2 interest in and to all oil, gas, coal, and other minerals in and under said land. The question is, multiple choice, who owns the mineral estate? A is Orville owner half, Rancher 1/4, Farmer 1/4. B, Orville owner half, Rancher reserved half, and Farmer gets nothing. Or C, Orville owner has nothing, Rancher has half, and Farmer has half. Or D, Orville owner has half, Rancher has nothing, and Farmer has half. The correct answer under the Duhigg rule is answer D. Orville owner reserved half when he sold the property to Rancher. When Rancher sold the property to Farmer, he attempted to reserve half, but he only owned half. So, to fulfill the warranty in the deed, the half that Rancher owned is conveyed to Farmer, and there is no more mineral interest for Rancher to reserve. This is consistent with SDCL 43-4-16, which states that grants are to be interpreted in favor of the grantee. So when you look at a warranty deed, once again, the warranty is that 100% of the described property is being conveyed to the grantee. In Rancher's deed, it listed the property, but it said Rancher would be reserving half of the minerals. So it's presumed that the deed intends to convey the surface and half of the minerals to grantee, which leaves nothing left for the grantor to reserve. When interpreting the Duhigg rule, the key question is not what the grantor purported to retain for himself, but what the grantor purported to give to the grantee. The Duhigg rule has not been applied in South Dakota yet, but it is the general consensus of courts that the Duhigg rule should be applied. And I've quoted some language from a recent North Dakota Supreme Court case. The effect of Duhigg is that a grantor cannot grant and reserve the same mineral interest. And if a grantor does not own a large enough mineral interest to satisfy both the grant and the reservation, the grant must be satisfied first because the obligation incurred by the grant is superior to the reservation. And I do have to correct in my written materials, it says the word before at the end of the quote. It should be, change the word before to because. That should be because, not before. Also in my written materials on page 5, I have provided language that can be used in a mineral reservation in a deed that avoids the Duhigg situation. If you look at the language that is in bold, it says that the grantor reserves an undivided half interest of the interest, including future interest, if presently discernible, now held by the grantor. In my example, if Rancher had included this language that he reserves 1/2 of the interest he now holds, Rancher would have ended up with a quarter interest. Farmer would have received a quarter interest. But because the reservation in the example showed that Rancher said that he conveyed the property to Farmer and reserved half of all of the minerals, it's presumed that the other half goes to grantee, leaving nothing for Rancher to reserve. I'll give you an example of how that works. Example 7. Orville owner owns the surface and 100% of the minerals. Orville owner conveys Whiteacre to Rancher by warranty deed and reserves an undivided 1/3 interest in all oil, gas, and minerals. Rancher then conveys Whiteacre to Farmer by warranty deed and reserves an undivided 1/2 interest of the interest now held by grantor in all oil, gas, and other minerals. The question is, who owns the minerals? Is it Orville owner has 1/3, Rancher has nothing, and Farmer has 2/3? Is it Orville owner owns 1/3, Rancher owns 1/3, and Farmer owns 1/3? Or is it Orville owner owns 1/3, Rancher owns 1/6, and Farmer owns 1/2? Or is it B, I have no idea, you lost me? Well, the correct answer is B. Orville owner reserved 1/3 when he conveyed it to Rancher. Rancher then reserved 1/2 of the interest he now owns, and 1/2 of 2/3 is 1/3. And Farmer then receives the remaining 1/3. The next mineral title point I wanted to talk about was reservations to third parties and the stranger to title doctrine. I've quoted language right out of the South Dakota Supreme Court. A reservation in a deed must be to the grantor or to one of them, where there are 2 or more, but an estate cannot be created in a stranger to a deed by a reservation or recital therein. Here's an example. Rancher owns the surface and 100% of the minerals in Whiteacre. Rancher conveys Whiteacre to Farmer, reserving unto himself and sister Susie each an undivided 1/4 interest into all oil, gas, and other minerals. Question is, what interest does Susie have in the oil, gas, and other minerals? Under that reservation, Susie owns nothing. Susie's a stranger to title, and she has no interest to reserve. The reservation to Susie fails. If you look at the example, rancher owned it all in his name. He cannot reserve half to his sister. If he wanted his sister Susie to have some, he could have deeded her an interest, but he can't reserve it. She doesn't have an interest. Question 2, what interest does farmer have in the oil, gas, and other minerals after the deed is recorded? Farmer owns 3/4 of the oil, gas, and minerals. The reservation attempted to reserve 1/4 for rancher and 1/4 for sister Susie. We know this reservation to sister Susie fails, so farmer ends up receiving 3/4 of the minerals. Final question is, what interest does rancher have? Rancher reserves 1/4 interest of the minerals. The stranger to title doctrine applies, as I've discussed. There has been a split of authority among the states on whether that doctrine should apply when it comes to reservations by spouses. For instance, husband and wife may own the ranch. They sell the ranch. Husband in his name alone owns the ranch. He sells the property to farmer, and in the deed, rancher deeds the ranch and reserves a half interest for rancher and rancher's wife. The question is that reservation good for rancher's spouse? And South Dakota has not had to interpret this yet. I think that we've got to apply the laws we know it, and that would be that a reservation to the spouse would fail. But the state of Wyoming, for instance, does not recognize the stranger to title doctrine when it comes to spouses. And in Wyoming, the reservation would be good, would be valid for the spouse, even though she was not a title holder of the property at the time of the sale. And I've got a short example of that. Example 9, rancher owns the surface and 100% of the minerals. Rancher and his wife, as grantors, sign a warranty deed conveying White Acre to farmer and reserve unto rancher and wife an undivided 1/2 interest in all oil, gas, and other minerals. What mineral interest does rancher's wife own? Depends. Hasn't been interpreted in South Dakota. Under prevailing law, I think the reservation to the wife fails, but there is some contrary authority in other states. What mineral interest does rancher own under that reservation? In my opinion, he owns half. Another common question that comes up with mineral title is gravel a mineral? An example, rancher owns the surface and 100% of the minerals. Rancher conveys White Acre to farmer by warranty deed and reserves all oil, gas, and other minerals. The question is, who can mine the gravel on White Acre? And the answer is, it depends. Gravel is generally not considered a mineral. However, if you look on the next item, number 1, if the patent for the land was issued under the Stock Raising Homestead Act of 1916, gravel is included under the reservation under that act to the U.S. government. The only way to determine that is to go look at the patent and see what act the patent was issued under, and if it's issued under the Stock Raising Homestead Act, the gravel belongs to the U.S. government, period. In South Dakota, the Attorney General has issued an opinion that says gravel is not part of the mineral estate, so the state reservation of minerals does not apply to gravel. And in private transactions, gravel is not included as a mineral unless it is specifically called out in the reservation. Another issue that practitioners need to be aware of is state minerals. My example is the state of South Dakota owns the surface and 100% of the minerals in Whiteacre. The state conveys Whiteacre to Orville owner by warranty deed with no mention of the minerals. Orville owner later conveys Whiteacre to rancher by warranty deed, reserving an undivided half interest in all minerals. The question is, who owns the minerals? And the answer is the state of South Dakota. The law in South Dakota, I'm not getting my next page here. The law in South Dakota set forth in my written materials is that by constitutional provision and by statute, the state of South Dakota reserves the minerals even if there is no express reservation in the conveyancing deed. As a matter of law, if the state of South Dakota owns the minerals or owns the property, they will always retain ownership of the minerals. In my written materials, I've also shown a good source for quick reference to see if there are any minerals owned by the state. The Commissioner's School Public Lands book called South Dakota's Mineral Acres is a comprehensive list of all of the minerals owned by the state of South Dakota in every county in the state. The next topic I'd like to talk about is federal reservations. Briefly, the U.S. government often reserved all or part of the minerals in patents. A review of the patent is required to determine if the minerals were reserved by the U.S. government. However, there may be other subsequent reservations in the chain of title. There are over 57 million federal mineral acres in the United States that are overlaid by private surface, so it's something that should be consulted to determine if the federal government has reserved those minerals. I've given you a site to the BLM's website that is a quick, easy reference to determine if there are federal minerals on land. And to close my presentation, I wanted to point out, if you're looking through the South Dakota title standards, specifically Title Standard 808, it talks about the South Dakota mineral title standards, and it refers you to those. Don't spend a lot of time looking for those because they don't exist. There are no South Dakota mineral title standards. However, recently, the State Bar's Real Property, Probate, and Trust section has appointed a committee to start developing some mineral title standards. That concludes my presentation. Thank you.
Thanks, Dwight. Since Amy couldn't be here this morning, you may have guessed that she's probably not going to give the update. So Bob, in his presentation, graciously covered the updates that we wanted to tell you about. We will take a break, and let's reconvene here at the regular time, 1 o'clock, and we'll do the afternoon session. So you're going to have a little bit longer period of time for lunch. Thank you.
Any objections? Hearing none.